Hi, my name is Lucas Lisitsky. I'm a student at Osgoode Hall Law School in Ontario, and in this episode of Case Law Minutes, we're going to talk about the Canadian Supreme Court case of Miglin versus Miglin. This is a family law case that pertains to the subject of separation, specifically separation agreements and how the court understands these agreements in relation to applications for spousal support, where the separation agreement itself released one of the parties of the right or entitlement to spousal support. Now, quickly before I begin, a disclaimer. This presentation is for informational purposes only. If you're dealing with a legal problem, it's a good idea to consult a lawyer because they'll be able to give you advice and information that pertains to your specific circumstances as they may be. Now, the Miglins were an Ontario couple that got married in 1979. They had 4 kids together. They had a family home as well as a property up north, which they operated as a family business, a lodge of sorts. They unfortunately got separated in 1993, and they, after a year of negotiation, decided to sign a separation agreement that would allow them to settle their financial and personal affairs flowing from the divorce as they saw fit. They divided up their properties. The mother would get the family home, the father would get the family business up north. They would have joint custody over the children. Now, keep in mind, the language of custody is not used so much in the modern Divorce Act. It's been issued in favor of parenting time and decision making, but at the time, custody was the term that was used. Children would primarily live with their mother, and the father was to pay about $60,000 a year in child support to the mother. And in turn, the mother would release any entitlement that she had to spousal support under Section 15.2 of the Divorce Act. Now, after they signed the agreement, unfortunately, relations soured between the two former spouses. The mother would eventually apply to the courts for sole custody of the children as well as for spousal support. Now, this latter part is most relevant for our purposes because, as you recall, the separation agreement specifically released the mother of any entitlement she had to spousal support under the Divorce Act. So this case gets appealed all the way to the Supreme Court, and the Supreme Court is left with the decision of how they will decide whether to exercise discretion in modifying the separation agreement if they so choose to grant an order for spousal support. They crafted a 2-step test that would allow them to decide whether to uphold, modify, or repudiate the separation agreement, and that test is as follows. It can be found on the paragraphs 80 to 91 of the case itself, and these are the most cited paragraphs of this case, so it's good information to have. Stage 1, the court looks at the agreement at the time that it was made and agreed to. They take a look at whether the agreement keeps with the objectives of the Divorce Act, of which there are several. Examples include equitable sharing of the economic consequences of marriage and its breakdown. Another principle would be self-sufficiency or autonomy, gradually allowing spouses to be self-sufficient after a period of time. And another thing that they will look at is whether or not there was a vulnerability that was exploited by one of the parties during the negotiation process. If this is the case, then that would be a reason for the court to exercise its discretion in modifying the agreement for the sake of fairness. Now, for the second part of the test, the second stage, they don't look at the time of the agreement, but rather the time that the spousal support is being applied for. So this is after the agreement has been made. First thing they look at is whether the agreement still keeps with the objectives of the Divorce Act, in light of changing circumstances, etc. And they also look to see whether, after changing circumstances, the agreement still would be keeping with the parties' intentions. Now, obviously, the court would allow for a certain degree of change that they would consider foreseeable and in keeping with the parties' original intentions. For instance, the cost of childcare or the job market changing, etc. Reasonably foreseeable things. But they also say that there are some changing circumstances that are unforeseeable and would be substantial enough to necessitate an adjustment of the separation agreement. Now, one thing that's important to note is that, again, the separation agreement may be adjusted by the courts. It might be repudiated as well entirely. And it's up to the court's discretion how much they decide to modify or redline when it comes to these separation agreements. Now, the court's decision in the Miglin case is that, firstly, they didn't find any substantial departures from the objectives of the Divorce Act in the separation agreement. They found that there wasn't evidence that demonstrated that the mother was exploited during the negotiations. She had adequate legal counsel throughout the negotiation process. They also found in the second stage that there was no evidence to demonstrate that the objectives of the Divorce Act were no longer met after a period of time. And they found that while there were some circumstances that had changed, such as the cost of childcare, these changes were foreseeable at the time that the separation agreement was negotiated, and as such, they did not constitute a substantial change in circumstances that would necessitate the court modifying the separation agreement. So the court upheld the separation agreement and did not grant the order for spousal support in this case. If you'd like to read the Miglin case for yourself in its entirety, you can find the full text on the Supreme Court website as well as on Canly. Links are provided on the screen here. And if you're interested in more videos like this or videos in this series, do check out the Litigation Help channel and subscribe. This has been Lucas Lisitsky, and thanks for watching.